Hey guys, it's me, Sylvia. I am back. Um, we got some info for you guys. We got some info, and I have my guests helping me out to read some of the stuff that just came in from the government. Of course, they are in opposition. Of course, we know they would be, but we just want to hear some of the stuff they have said. So, without further ado, we will have my wonderful guests, Miss Melly Mel, the only Mel Cruise show, and Miss Purple Couch, speaking from the Purple Couch. Hey, ladies.
Hey,
Hey.
oh, where's Melly Mel?
Where's Mel? What happened to Mel?
I'm here. I was on mute. Hi,
Oh,
y'all.
Hey, how you doing this afternoon?
Doing great. Real great.
okay.
Y'all, did you get a chance to read what the opposition from the government?
Yeah, I'm so
No,
tired of her. Mm,
no. Isn't that the whole truth, nothing but the
ooh,
truth?
sick of her.
Ooh, chow, 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 chow. Did you read the bottom part, y'all?
Yeah, she tried to throw a little salt. I'm just
So,
sick of her.
some shade, huh?
Yeah,
Mhm.
but she needs to shade it on herself.
Man, these people, man, I tell you. Oh,
Mm,
Lord,
mm,
Lord, Lord,
mm.
Lord. Okay, hold on a second, y'all. I'm getting ready to share my screen with you guys in a minute as the ladies here. I don't know who's going to do it for me. Whichever one wants to do, go ahead on. It's a
Melly
short.
Mel.
And I was saying purple couch.
Ah!
Melly Mel, Melly
However
Mel,
y'all want to do it.
Melly
Well,
Mel.
well, one second. Let me just go ahead on and open it up for the people so they can take a look along with us and read what the government is opposing to. I'm so tired of these people, man. I am so tired of them. They always got some shenanigans going on.
Well, her
Totally.
standards are low. That's bottom line. It's just low standards.
Yeah. All right, go guys. Without further ado, we're to go ahead and bring it to you guys because we're what? Sylvia's on the what?
The infamous Sylvia on the
Hey,
case.
oh,
On the
yes,
case.
yes.
On the
On the
case. All
case.
right. All right, guys. Here we go. Welcome everybody. Here we go.
All right, dear Judge Donnelly, the government respectfully submits this letter to strenuously oppose the defendant's March 29th, 2022 motion to adjourn the sentencing in the above captioned matter. The defendant, Robert Kelly, is currently scheduled to be sentenced May 4th of this year at 10 a.m. The court set the sentencing date on September 27th, 2021, the date the jury found the defendant guilty on all counts. The defendant's current counsel, Ms. Jennifer Bonjean, entered her notice of appearance approximately 1 month later on October 29th of 2021. In her motion, defense counsel seeks an adjournment of the sentencing until a date after the defendant's trial in the Northern District of Illinois, which is currently scheduled to commence August 1st, 2022, primarily because she claims she cannot otherwise adequately protect Mr. Kelly's constitutional rights at sentencing in this case without compromising his Fifth Amendment rights in the Northern District of Illinois case. Defendant's motion at number one, even assuming arguendo that is so, there are other ways to effectively address defense counsel's stated concern that she cannot advise Mr. Kelly to be examined or interviewed by a mitigation expert for sentencing in this case if his words might be used against him in some manner in his pending Illinois case. As an initial matter, given that the defendant has essentially challenged every aspect of his conviction as set forth in his post trial motions, and likely also intends to appeal his conviction should his post trial motions prove unsuccessful, it's strange credulity that the defendant would say anything to a potential mitigation expert that would incriminate him in the Northern Illinois case matter. To the extent the defendant intends to appropriately highlight his own background and characteristics as Section 3553 factors the court should consider at sentencing as mitigation, he can do so and surely intends to do so without admitting his guilt, given his likely appeal. In addition, the speculative concern can be entirely ameliorated by adopting the following procedure. Why are we going to take her advice? To the extent the defendant engages a mitigation expert, the court can permit defense counsel to file the mitigation report or relevant portions of it under seal. The assigned AUSA, who constitutes a separate prosecution team from those prosecuting the Illinois case, will not share any such mitigation report with anyone involved in the Illinois prosecution, and to the extent there is any concern in this regard, would welcome a court order further prohibiting any such disclosure. Such a procedure would entirely eliminate any risk that the defendant's words might be used against him in some manner in his pending Illinois trial, and thus obviate the defendant's purported need for a sentencing adjournment. Nor is it accurate to suggest that there is no prejudice from adjourning the defendant's sentencing. Under the Crime Victims' Rights Act, the defendant's victims have both the right to be reasonably heard at any public proceeding in the district court involving sentencing and the right to proceedings free from unreasonable delay. As proven at trial, the defendant engaged in wide ranging and extensive criminal conduct involving multiple victims with impunity for decades. His victims have waited years to see the defendant held to account and sentenced for his crimes. Moreover, in reliance on the date set by the court in September 2021, many victims have cleared their schedules to travel from other states to New York to attend and be heard at the May 4th 2022 sentencing hearing. Delaying the defendant's sentencing until his Illinois trial, which will presumably last several weeks, is not reasonable in the circumstances, particularly where, as here, the above described procedure will alleviate defense counsel's purported constitutional concern. In addition, as the court is aware, the defendant is currently housed in Brooklyn, New York, while awaiting sentencing. The United States Marshals will need to arrange for his in custody transfer to Northern Illinois prior to his trial there. Delaying his sentencing until after his Illinois trial is inefficient and will result in needless expense and delay by requiring his transfer back to this district for sentencing after the Illinois trial and then back again to Illinois for sentencing there. Finally, defense counsel's other professional obligations are not a basis to adjourn the sentencing hearing, which has been on the calendar since September 27, 2021. Defense counsel was aware of the sentencing date when she entered a notice of appearance in this case and when she later decided to become the defendant's counsel in the Illinois case. Like all lawyers who appear before this court, defense counsel handles more than one matter at a time, which is the norm for experienced litigators. As an experienced attorney, defense counsel is undoubtedly capable of meeting her professional obligations in this case and her other cases. Submitted.
Mm, not
Okay?
respectfully.
Just submitted. Just thrown up in there.
Mm,
Elizabeth Geddes and that team.
mm, mm.
And I will read this footnote where she says, indeed, the same alleged concern would apply in the event the defendant were to be granted a new trial after appeal. Given that the same purported concern would exist even after the Illinois trial, the existence of the Illinois trial cannot serve as a valid basis to delay the defendant's sentencing.
Whew.
Or low standard ass.
Mm. And then, wow. Then you're going to try to. Mm.
The audacity.
Mm,
Like
mm,
she has a standard.
mm, mm, mm.
What is the judge going to do? That's what I need to know.
Me too.
I'm tired of it all. I'm just sick of it. I'm sick of it.
So did she basically convict him because she said, and then for him to be transferred back to Illinois for sentencing?
Mm,
He hasn't had his trial.
come on.
So
Yeah,
what are you saying and what are you doing?
thank you. And not only that, now all of a sudden you're concerned about costs. It would be too expensive to run them, to run them up and run them back and then run them back again.
Really?
Stop it.
Mm, mm,
Now I did miss the part, and I know that's in the other motion, but what other case did Bongine say she had that was conflicting with this?
The case in California with Bill Cosby, and then she has two Illinois case.
Mm. I wonder what this judge is going to say and do.
I knew they were gonna say something about the her having another case because that was one of the things that Judge Ray mentioned to Cardi's lawyer when Cardi's lawyer mentioned that
Yeah,
she
that's
had
true.
something, and he says no. He says you knew you had this case, and this takes precedence over what you got going on.
Well, but when when Judge Ray said that, that's because they were actively in
A
court.
trial.
Yeah.
Right.
Hmm. In a trial.
So
This case is over with already.
thank you. And not
Right.
only that, but this was submitted in March, the end of March. We're just getting into April. So these folks saying, they can change their plans. It's not like this is a 48-hour notice.
Exactly.
Come on,
Exactly.
Then
stop.
they're saying that basically the alleged victim is they planned plane flights and all that. Stop lying. They ain't getting no
They
flight.
lying.
Stop it. They
They
just
are
want to do some
lying.
more album release
Yeah, so
parties. If they don't get
pussy.
out of here, well, it's too much.
Yeah.
It's going to be interesting. I wonder when the judge is going to respond to this then.
He can't respond until Bonjean get another chance to come back on the 7th.
Mm.
She has one more say over it.
Well, my confidence is in Bongine, that's for sure.
Yep.
Because she wouldn't have put any of that stuff in there unless she already knew.
Mm-hmm. Yeah. She got her excessive pages approved. Judge Donnelly approved those.
For so that was at Getty's because y'all I've been out the loop a little bit today.
No, that was Bonjean's request yesterday for extension of excessive pages for her reply to the government's opposition.
Mm, okay, good. And so this judge said yes, it's cool.
Yeah, she approved it.
So I really wonder more about this procedure though. Like, what is this mitigating person going to do? Like, what will they ask him that he would that Kels could possibly uh, put himself
Incriminate
in a
himself.
jam? Yeah,
I mean,
Well,
his whole background. You're gonna pull out everything from his background. I
right.
mean,
And it's the pre-sentencing report. And so they go
deep,
everywhere,
deep.
or everything.
From the time you was a little baby, any bad girlfriends that you had, any bad relationship, good relationship, they dig deep inside a person back. That's why it's taking so long too.
oh, and then these witnesses can get up there and say, "Your Honor, I think you need to throw the book at him and bury the key."
So
They
they're
impact
going to be like
sentence.
their impact.
Mm-hmm.
You know how they have impact
Statement.
statements.
Yeah.
Yeah, they'll be able to say
Mm.
it in person. But the pre-sentencing report, I mean, it goes. The judge used to have me to read them and kind of summarize them for him because some of them could be very lengthy,
Yeah.
and some of it though was wild. But it's all a part of mitigating what they will propose as far as his sentencing, how many years, et cetera, et cetera.
Oh my goodness. This thing has gotten so far out of hand. It's just gotten so far. I mean,
Yeah,
it
it's
been it been
ridiculous.
got out of hand, but this is ridiculous now. It's just ridiculous because this man could. I mean, how many? What is? Do we know what Getty's wants him to? How much time she wants him to serve?
We don't know.
That would be in the pre-sentencing report, but they recommend.
Right.
Yeah,
I don't see the pre-sentencing report.
no, it's not done yet.
Yeah.
Yeah,
Mm, mm, mm.
All right, guys, I'm about to hit to end this, and we'll wait for the next motion to come in. Thank you, guys, ladies, for helping
Sure,
me out. All
absolutely.
Welcome.
Thanks for asking. Our
right.
Yeah.
pleasure.
I appreciate y'all, but I'm gonna get
Appreciate
ready
you
to
too.
go. All right, hon.
All right,
Okay.
so see
All right,
y'all.
guys. All right,
Okay.
see you
Bye bye.
later. Bye.